Welcome, everyone. Just letting folks in from the waiting room right now. Give us just a moment. Just a few more moments while we let a few more folks in from the waiting room. Okay, I think we'll go ahead and get started. Welcome to the webinar here today. This is a webinar featuring Michelle Dellino from Dellino Family Law Group, and the topic is different approaches to divorce from high conflict to uncontested. I'm going to have Michelle introduce herself and get started here in just a moment. First, I'm going to introduce myself and tell you a little bit about the format today. My name is Melissa Rosenberg, and I'm actually a therapist here in Seattle. And one of my primary specialty areas is working with clients who are going through different phases of the divorce and separation process, whether they're early in the stages of contemplating divorce and trying to determine if it's the best path forward, or in the middle of a high conflict or highly emotional family law situation, or on the other end where clients are trying to navigate their next path forward. I work with both individuals and couples, and I am here today as a moderator for this webinar. And so what we're going to do, I'm going to turn it over to Michelle in a moment. She'll introduce herself and then start launching into some content. So we're going to tell you, Michelle's going to deliver a lot of information about high conflict and uncontested divorce and everything in between, and a lot more about what that looks like. And then we'll take your questions. And so I'll be fielding those questions to Michelle. And the way that that works is you can post your question either in the Q&A or in the chat feature at the bottom of the Zoom screen. The chat, will just come only to me. So it's just you show up as your name, but it only comes to me. And then I will pitch the question to the group. If you put it in the Q&A, then you can mark yourself as an anonymous attendee, or otherwise it will show up as your name. So either way, whatever you're more comfortable with. So yeah, looking forward to having, a lot of great information given to you all today, and hopefully some great questions answered too. Sometimes when you ask a question somebody else didn't think to ask, it's just as helpful to the other people in the room. All right, so with that, I will turn it over to Michelle and we'll go ahead and get started.
All right. Hi, I'm Michelle Dellino. I'm a divorce and family law attorney in Seattle. I'm the owner and actually founding attorney now of Dellino Family Law Group. We have offices in Seattle and Bellevue, and we actually help clients all over Washington State. So I've been practicing family law for over 15 years. We handle here at our firm really almost every approach to divorce, from negotiated settlements, mediations, to high conflict, heavily litigated divorces. So I thought it would be a good idea to talk with you about different types of approaches to divorce, because whether you're thinking about the process, you're in the process, you don't really know what's going on, the approach that you take in your case can really make all the difference. And I think sometimes people are under misconceptions about what that can mean and what's realistic for somebody's situation. So we're going to talk about a lot of different approaches to divorce. Like Melissa said, if you have questions, I definitely want to answer your questions. I think it's beneficial for you to kind of think in real time. So we'll take some time to do that. What I'll do is, as I'm going through the content, stop, take some questions, and then get back on track with the content to try to cover all the basics I have for you today. But at the end of the day, I think the most important thing for you to know is if you're asking me a really detailed hypothetical question, we might not be able to answer that because a hypo isn't going to apply to everyone, and it's going to get into a situation where I would need to have a conversation with you and know more. So if you have that kind of a scenario, schedule a consultation. Doesn't have to be with me, with any attorney. I don't care who it is, but just someone to get fact-specific information. If you do ask some fact-specific questions, we might be able to pull out parts of that would be helpful. So if we're not answering your question in detail, that's why. I'm an attorney, but I'm not your attorney, unless we have an attorney-client relationship. This is a public forum, so while I'm not going to share any information that you ask, this is not a confidential setting. So keep that in mind. If you need legal advice, you need to get a consultation with an attorney in a private setting. This is legal information, so nothing I am sharing with you should be taken as legal advice, but it's information from somebody who knows. So anyway, that's why we are here. The whole idea of this webinar is to give you some more information and give you some clarity. So maybe you have some confidence moving forward, or you kind of know what's going on or where to start. Divorce can be extremely confusing, extremely disorienting, disorienting. It can take your normal and plunge you into a place really that you never thought you were going to be. And so knowing what's coming, what steps to take, and how you might be able to approach your divorce, or how you might have to approach it is really important. So I'm going to talk about four different types of divorce today. Okay. So the first one I'm going to talk about is kind of the most common, and that's a cooperative divorce. And this is a term that not a lot of people use. So, but it kind of describes the status quo for most people. So we're going to talk about cooperative divorce. We're going to talk about collaborative divorce, which is a term that's thrown around a ton. And people like to talk about collaborative divorce, and it sounds all very well and good, but it's not necessarily appropriate in every situation. We're going to talk about, actually, we're going to talk about five because I've added another one. We're going to talk about what I call the DIY divorce, if you're trying to do it yourself, what that looks like. And then we're going to talk about an uncontested divorce, which is a little different than a DIY divorce. And then finally, we're going to talk about a high conflict, fully litigated divorce. So that is one, two, three, four. That's actually five, since I decided to kind of break out the DIY and the uncontested, which is something I think that's important to clarify. So we're going to talk about all of those. Let's start by saying this. No way that you approach your divorce is right or wrong. What's right for one person is not right for someone else. The best advice I can give you as you start to think about divorce is I mean, your friends and family, they mean really, really well. They do. Everybody knows somebody that's been divorced, that's been through some kind of a process, and they all want to give you their opinion. I can tell you that for sure. So I'm not saying don't listen to your friends and family, but keep in mind that their situation isn't your situation. And even though there might be parallels, everybody's different. Everybody is soon to be former spouse is different. Every set of facts is different. Every court is different. Everything's different. So you can't say, oh, well, this happened in my boyfriend's sister's case, or this happened in this case. Why isn't that happening in mine? Why isn't this working? Like that, just take that away out of your mindset, and your life is going to be easier. When you are constantly comparing your situation to someone else's, it's not going to work. So don't do that. Don't listen to friends or family. Um, who should you listen to as I get started? You should listen to an attorney. And I'm not just saying that because I am one, but I can tell you I would never let a friend or family member that I actually care about enter into a divorce proceeding without at least consulting with an attorney at some point throughout the way and on their settlement, if not to have full representation. If you've been to my webinars, my meetups, or anything before, or even seen me on TikTok, you might know that I would tell you that I think I know a lot about a lot of things, but I know what I don't know. And so I know a lot about tax. I know a lot about finances, but I'm not a CPA. I'm not a financial planner. I know a lot about dealing with my own sports related injuries, but I'm not a doctor or a physical therapist. If I have a tax problem, I go to a CPA because they know what they're doing better than I do and can handle something objectively. If I have a financial situation, I have a financial advisor. If I hurt my knee for the 20th time, I see a medical professional. So what I'm saying is, while you can DIY some things, a divorce is the most intertwined, complicated legal contract that you're ever going to enter into with someone. And so as you dissolve that legal contract, it would behoove you to get legal advice. So you don't be one of these clients that come to us later and say, oh, I agreed to all these things because I thought I had to, or I didn't know, or one of these clients that comes later and is like, oh, we did our own settlement. I just had this the other day, but all these things got left out, and so now it's not enforceable. What can I do? You're creating something that you want to end, going on and creating more chaos for you later as you try to move forward. So don't do that. This is my best advice. Don't do it. And I don't care what attorney you hire. It does not have to be me. Get an attorney to advise you. That is what we do. So that's my plug here for being well informed and advised. You've taken a great step by being here today. So this is like how you get information. Start somewhere. Start here. Okay. Cooperative divorce. So you probably haven't heard this term before. I'm not going to say I came up with it. I like to use it. I didn't necessarily come up with it, but I think it really describes what most people's situation is like. So in a cooperative divorce, it's kind of, we'll talk about collaborative in a minute, but it's kind of a divorce with flexibility is how I describe. So most people will have their own legal representation. They'll each have one. And when you each have legal representation, you each have your own objective person to help you and help position you and give you advice, okay? And that person is not required to withdraw if you don't reach an agreement the way they are in collaborative divorce. So pretty much you've got legal representation. Everybody has their own. But you are, just because you have an attorney doesn't mean that you're approaching your divorce with what I call like scorched earth tactics. You're not looking to burn everything up. You're not looking to go into litigation and fight about every little decision you have to make in court. You have the right to go to court. You might solve some issues in court, but you are committing to the process of being cooperative. What is being cooperative going to do? It means the parties are committing basically to try to seek an out-of-court resolution through settlement discussions, through mediation. Litigation remains an option as necessary, but it's not your first option. You have attorneys that are trying to cooperate, exchange financials instead of get into expensive discovery if possible, try to come to agreements rather than running to court for a temporary order on every little thing. You're trying to be cooperative. But you're each getting advice, and you have the right to go and litigate in court if you need to. In a cooperative divorce, it's not uncommon if something can't get resolved, go to court, get it resolved, and then get back on track with cooperation. You might exchange financials, or you might do some discovery, but you're still trying to cooperate. You probably will resolve your case in a mediation. You won't probably be in a trial. Um, it's really like a collaborative divorce, but with more flexibility, privacy, and negotiation. It's what most people do. 90% of divorces don't resolve in a trial. They resolve through negotiation, maybe a little bit of litigation and mediation. So a cooperative divorce is two parties committed to negotiate, but still want to have the option of court if negotiation fails. It's what most people do. It's the majority of most cases that are represented by an attorney who don't end up in trial. So to me, it is the best approach because it gives you the options to litigate if you need to, but that's not your first approach. You're going to try to save time and money. You're going to try to preserve some kind of, I would say, like emotional reserve for yourself as you move through it. And it's really what most people do. So we can talk more about that if you have questions. But if you're in the middle of a divorce, you might be in a cooperative divorce. Or maybe you'd like to be, but this is the thing I will tell you. Both parties have to be committed to a cooperative divorce or it's not going to happen. And sometimes you might start it out and think, we're going to cooperate. And then somebody does something and it goes off the rails. You can always bring it back. Or you might start where somebody thinks, I'm going to litigate and take this other party to court for everything. Then they see how expensive it is, then they see how to control it can get, and all of a sudden they want to start to cooperate. So a lot of it also can depend on the attorney that you have or the attorney that's on the other side. Some attorneys, most attorneys, are good at cooperating, negotiation, and they want to do that. Contrary to popular belief, most attorneys don't love to go to court and try to burn everything down. Like, we don't enjoy doing that because it causes stress for our clients, a lot of unnecessary work. And even though, it's more expensive, which you might think is better for us, it's really not because we have other things that we want to do and we want to get you through it in the best way possible. So anyway, cooperative divorce, probably what you're doing. No definite path that it has to be this way or that way. It's a commitment to trying to cooperate. It's best for people who want to negotiate, but keep the option for court open. So let's talk about, Melissa, before I move on, is there anything you want me to take right now?
No, I don't see any questions right now. I just wanted to
Okay.
kind of pipe in though and say, a lot of clients that I work with who are going through divorce
Yeah.
processes, or actually especially who are considering divorce processes, but in, a therapy space of trying to figure it out, are fearful of the all or nothing myth out there about divorce, right? That it's either going to be, I'm going to bottom barrel do this by myself and I'm not going to know what I'm doing, or we're all going to get along or it's going to be this terrible horrible court situation. And so I think it's really valuable what you're saying about all the middle ground that exists that not everyone's really aware of.
Yeah, I actually totally agree with that. And a lot of people are scared. They're scared to do anything because they think, oh my gosh, the minute that an attorney gets involved, we're going to trial. It's going to be this ugly situation. Well, no, I mean, really, an attorney gets involved to try to advise you on something that you need advice on. Like, that's part of what we do. We're not here to just burn it down. Some attorneys are, but don't get one of those. But like Melissa said, or you think I'm totally on my own in like this DIY situation, and that's not true. Cooperative gives you an in-between, and it's how most people get through divorce. So great point, Melissa. Let's talk about collaborative divorce because this is something that you might have heard about. And I don't like to be, let's just put it this way. I don't like to be negative about collaborative divorce. I don't do a lot of collaborative divorce, but I am collaboratively trained. I've gone through all of the collaborative training. I've handled some collaborative cases. I think in some settings it's really, really good, but I think there's a lot of misconceptions about it. And I think it can be more expensive. And we very often get clients who what they call have fallen out of the collaborative process. So let's talk about what it is. What is collaborative divorce? Different than cooperative. Um, it's a structured out of court process where both spouses agree to work together to reach a settlement. It comes with limitations. Now, when you enter into a collaborative process, there's actually a code in the revised code of Washington that talks about collaborative divorce. Both parties have to sign a participation agreement. It's very different. You're not getting your advice in private. You're not negotiating. You're negotiating face to face with the other party. Each party hires somebody that's typically trained in collaborative divorce. You don't have to be, but I would never hire an attorney to do a collaborative case that has not been collaboratively trained. So everybody they enter into a participation agreement to follow certain rules. Okay. And one of those rules is you'll never go to court. You'll never serve financial discovery from the other party. Everything will be transparent. That's fabulous in theory, but it's not reality for a lot of people. So once that process starts, you have collaborative attorneys who are supposed to help you negotiate in a cooperative manner. It happens in what we call the collaborative container. The collaborative container is like this container where there's people on the collaborative team. That's you, your collaborative attorney, other side, their collaborative attorney, other collaborative professionals. There might be a realtor. There will be like a financial neutral. There might be some kind of a parenting person to help you with the parenting plan. But there's a team of people and you meet together. Neutral financial experts, child specialists, maybe a divorce coach, but that's a whole other thing that I don't encourage, to address financial, emotional, parenting concerns. You try to work everything out like in these meetings. So if you're cool to sit around with your spouse and have these conversations all out in the open and have that be the open discussion, maybe this is the route for you. It is not the route for most people. If there are types of cases that will not screen into what I call collaborative or should be screened out. Domestic violence, basically where there are power and control dynamics, extreme substance abuse issues. None of those cases should be in a collaborative process. Sometimes, unfortunately, people don't say no and they agree, but they are supposed to be screened out. So, uh, basically, if the process fails and litigation becomes necessary, you think somebody's withholding financials, you can't come to an agreement, the collaborative attorneys have to withdraw. You have to start over with new attorneys. That's part of the participation agreement. Why? Because you are all out in the open, everybody's talking about everything, there's not the same level of confidentiality, and you have participated in the process that now can't move forward with those same people to litigation. So a lot of time you have to start over. Who is it best for? It's best for people that want to avoid court, they want to maintain privacy, and they really want to work together to reach an agreement, like hand in hand, almost with the help of professionals. But you really need a high level of trust and transparency because you've agreed, if you won't pay me, I'm not going to go to court and ask for it. If you're not giving me the financials, I have no way to go to court and ask for them. So it's limiting. That's why I say I like cooperative better, because you still take that same approach, but you're not forced to be face to face with someone that could be a trigger for you. You're able to get legal advice in private. And if you can't get a resolution, you can go to court without starting over with another attorney. That being said, I do know some really fabulous, really great collaborative attorneys, and that's all that they do. So I typically will refer collaborative cases to those people because they will screen it in if it's something they really want to do. There is a misconception that collaborative divorce is somehow less expensive because you don't go to court or faster. That's not true most of the time because you have to have this series of meetings to agree on things. You're paying a lot of professionals to be there. There's no real timeline because you haven't filed a case the way there is in a cooperative or litigation case where we have a case schedule. Nobody's filed anything yet for the most part. You usually wait and do that later after you have an agreement. So it can drag on forever. I've seen people in the cooperative process for a couple of years before they've given up on it because then they don't want to give up because they don't want to start over. And it can create a real holding pattern for people that's difficult. And it can be expensive for numerous meetings and talking to your attorney, even if you're not litigating. Other times, though, I've participated in some cooperative cases where we've been like, hey, this is collaborative, where we've entered into a collaborative process. We've been able to meet a couple of times and boom, we're done. But honestly, I've handled thousands of cases and that's maybe been two. So, and that's why I handle hardly any collaborative cases and hand them off to people where that's really what they want to do, because it can be a time-consuming process for them. So, if you want to avoid court, maintain privacy, you want to work together, you're really fully trusting of the other spouse, and you want to work within a collaborative container, it might be for you. But I think you definitely want to consider your options before you go down the collaborative process. So collaborative and cooperative have some overlap. One has more flexibility than the other. One, you're never going to court. One, you might go to court. So those are two very common approaches. So that's something to think about. Now, let's talk about uh, a litigation divorce. I don't even think people really use that term. I'm just trying to use it to distinguish. You might call it high conflict. You might call it anything you want. Some people will call it a dumpster fire, like whatever you want to call it, I guess. And Melissa has clients who deal with high conflict divorces. And the first thing I'm going to tell you before we start talking about it is get a therapist, get some support. And I'll tell you why. And then I'm going to let Melissa say a little bit before I talk about it. As someone who has dealt with a lot of high conflict over the years, I can tell you that high conflict is expensive. It's expensive because there's heavy work to do, but it also gets expensive for you as a litigant because you're emotionally drained all the time. And there's a big emotional aspect to the case, right? And not only do high conflict people need a therapist during divorce, I think everybody does. I think everybody does to be healthy anyway, but especially in a high conflict case, because instead of coming to your attorney at a high hourly rate, and talking to us about all of the emotional stuff that you're dealing with and how to handle this process because it's a process, it's a marathon, it's not a sprint. How do you deal with that? Well, I can't tell you. I mean, I can tell you my opinion, I can tell you all the legal stuff. I want to hear about it and I do need to know about some of it. But you coming and talking to me about how this made you feel and how it triggered and how to deal with it at home and yeah, I can't, I'm not trained for that. And you're going to be more cost effective if you're dealing with those things and how to approach your case emotionally and on a status quo level. You're going to be a lot better off if you're able to do that with a therapist in conjunction. I will also say, too, high conflict cases, I'm going to get into this, often have a high conflict parenting component. Sometimes it's just financial, but a lot of the time there's a parenting component, and mental health can be at issue, and who's the better parent, and what's in the best interest of the kids. If you have a therapist and you're taking care of yourself, that's going to be seen as an asset if you're going into court. It's going to be like, oh, this person is healthy. They have themselves together and they are taking care of themselves, as opposed to the person that's like, I don't need therapy, screw that. And there's a misconception sometimes that, oh, if this person's in therapy, that's going to be held against them. No, trust me, that's an asset for you. So you want that financially, you want it from an emotional perspective. And I'm not going to lie, it looks good for you too if you are in a parenting dispute. Melissa, do you want to chime in on that before I move on to the substance?
Yeah, yeah. Like Michelle's saying, I think that anybody going through any divorce could really benefit from therapy and in this process. And it's a major, major life change. It's a major, transition in your world. And even if it's your choice, even if it's, you know, the best case for you, even if you're excited about your next chapter, there's still major changes happening. There's usually a lot of grief emotions involved, even that surprise people sometimes, even if they feel like they're completely done with the relationship and they're happy to be moving on. It's complicated. There's a lot of complicated pieces. And so emotions are complex in this situation as well. So I really, really recommend having a therapist, regardless of the level of conflict. But certainly, if you're dealing with a high conflict situation where things are getting complex and the person you're divorcing from is contentious and wants to blow things up or wants to pull you into toxic communication loops or, is making things really difficult, you need to have support, adequate support to get through it. And in addition to therapists, I think it's really important to have a strong emotional support network around you. Michelle said earlier, people will give you all their opinions about your divorce. That's definitely true. That's not what I mean. I mean, just people who are going to love you and take care of you and support you through the ups and downs of this challenging time. That's really important. But also having a professional involved who can help sort through some of the mental health and wellness and emotional challenges associated is, next to essential. And it is gonna save you time and money getting through the divorce. I work with a lot of people who, need to get to mediation and they need to emotionally prepare for that.
Yeah,
They need to emotionally prepare for the meetings they're going to have with their attorney so that they can compartmentalize and show up and ask appropriate questions
yeah,
and not have it be, an emotional mess because there are a mess of emotions and those need a different place to be unpacked. So I
totally.
could go on and on, but I definitely, huge proponent of having adequate support in all areas.
Yeah, really good decision. Really, really good decision. Okay. What the heck is a high conflict litigation divorce? All right. It's what some people would call a traditional court-based divorce, where both people take pretty much every little issue to court and have the court resolve it. It doesn't just mean a trial. Let me give you kind of like the life cycle of a divorce case. I think this is really important for you. So when you file a case, a traditional case, and you need information right away and you need a status quo right away, you probably will also file a motion for temporary orders, and the court will decide temporarily who's going to live where, what schedule your kids are going to be on, who's going to pay who what money, who's going to pay the bills. And you'll basically be going to court. Everybody will be presenting their sides, and then you'll be arguing about it. Well, that's fine. Sometimes that's actually very necessary, but it's also very expensive and a contentious way to start your case. If you start your case that way, a lot of things continue to go that way. And sometimes you absolutely have to because you can't come to a agreement, and there's nothing wrong with that. But that's kind of where things start. A lot of cases after temporary orders will kind of get on track. Everyone's like, wow, that was really stressful and expensive. I don't want to go the whole way. And they try to be more cooperative. Other cases that are high conflict start that way, or they might start with a protection order because you need to get a protection order. And unfortunately, you might not want your case to be high conflict, but when there are things like domestic violence, substance abuse, assault, anything like that that's involved, sometimes you need to start the case getting protection right away. Sometimes we'll have to start a case with immediate restraining order to get someone out of the house or keep them away from one party or the kids. Sometimes if someone has perpetrated domestic violence, we'll start a case at the same time as a protection order. There's differences between restraining orders and protection orders. I'm pretty sure I have a video on that too that you can watch, or I can talk about it some other time. But it's emergency relief right away. When you start a case with emergency relief right away, everything is up, like everything's escalated, and people are in a very high conflict situation. And it doesn't mean that you want it to be that way, but sometimes you need it to be that way. So when someone comes to me and there's been DV abuse or financial abuse or coercive control or anything like this, or someone's been pulled over in a car with kids drinking and CPS has gotten involved, any of these kinds of things, and they come to me and they're like, oh, I want to go collaborative. I'm like, no, that's not going to work for you. You might like that idea, but that's not going to work for you. Also, a lot of people will come and they'll maybe be a victim of DV, or they'll be making excuses for the other party's behavior. Oh, it's a mental health issue. Oh, it's an alcohol issue. And they'll really just want to like walk on eggshells because they're used to walking on eggshells in the whole freaking marriage, right? And they want to do that in the divorce. Well, if you do that, a lot of the time, the other party's going to steamroll you, and you're not going to be able to make any progress. You're going to just agree with everything they say. A competent attorney is not going to let you do that. And you might need to litigate. Not everything, but maybe most things. So what's a high conflict litigation case? Most things are resolved in court or back and forth through attorneys and not in a cooperative manner. And it's kind of a lot more of what I would call a fight. And you might not want it to be that way, but you might ask for something simple through your attorney, like, give me the last 6 months of your bank statements and I'll give you mine. And they might say no. So then what do? You've got to serve discovery. So they have to give it to you. And then we go back and forth about that. Or somebody wants to take the kids on a vacation and it's not in the parenting plan. You got to go to court to fight about that because you couldn't come to an agreement. Or somebody wants to do this or that. Every little thing becomes a fight. You can try to diffuse it, but you need also competent counsel if it's going to become a fight, and someone that knows how to handle that and also settle things down a little bit and act as a buffer and a filter for you so you are not in the crossfire constantly. You can make it through a high conflict litigation case and not be in the crossfire. I mean, frankly, like that's our job. We're in the crossfire and we should be able to manage that for you. Will you have to have input? Yes. Will you have to have that icky feeling when you read something that the other side wrote about you? Yes. But you get to respond and you'll have help doing it. So all of this describes like this high conflict, clenched up, I don't want to deal with this kind of situation, but sometimes you have to because the other party is not going to be reasonable. I always tell clients this too. I want to be reasonable. I want to negotiate. I want to do this and that. I'm like, well, we'll try. But what you're describing is someone that's not, has a different definition of reasonable than you. I like to tell people this. Oh, I want to be fair. Do not say the word fair in your divorce. It does not exist. People will like, I want to be fair. Why can't he be fair? What you think is fair, what I think is fair, totally different things. There is two kinds of fare. One, you pay it to go on the light rail or take the ferry. It's a fare. You pay it, right? It's objectively a certain amount of money. Two, you go to the fair in September at the Puyallup, or you go to the Evergreen Straight Fair and you ride on some rides. That's it. You can agree on what those things are. You cannot agree on what is fair with somebody who is not rational. You just can't. So take that out of out of your vocabulary. Replace it with I want to be equitable. That's an arguable term. There's no definition of what that means either. It's more like a range, right? Take that out. And just realize you can't. Somebody said something to me, and I'm not saying your spouse is a terrorist, but someone's like, you can't negotiate with terrorists, right? Someone told me that when I was a really new attorney, because I was like, why won't they just agree to this? And the judge I was working for at the time was like, well, because they're like terrorists. You can't negotiate with them. They're not thinking like you or me. It was really important for me to hear and learn early on. So keep that in mind. You cannot negotiate with somebody that's not reasonable. Do not have the same definition of what's fair. And sometimes you need to go to court to have those answers given. So again, litigation, high conflict, traditional court-based process. Everybody basically brings their decisions to court, or you negotiate and hash things out through counsel in a more contentious way, and you have to go to court. Court involvement includes discovery, which is exchange of financials. It might be depositions to have people take statements under oath that you can use later, hearings, temporary orders, compelling discovery, maybe having a guardian ad litem appointed if you can't agree on one, and then possibly a trial. Anyway, it's an expensive and extensive process. Sometimes it's necessary. What's it best for? High conflict cases where there are concerns about DV, where somebody is unwilling to negotiate in good faith, because that's really what it comes down to. If people will negotiate in good faith, you can agree on a lot of things and move the case forward. You can agree on an expert to look at a business. You can agree on exchanging basic financials. You can agree on a temporary parenting schedule. You can agree on a lot of things through negotiation if people are willing to negotiate in good faith. If one person is not acting in good faith, or sometimes, unfortunately, both, the court's going to get involved. So buckle up and open your pocketbook, unfortunately. So that's one thing to know. And we'll talk about attorney fees in a minute too in these different settings. So anyway, we've talked about litigation, we've talked about cooperative divorce, and we've talked about collaborative divorce. I want to talk about DIY divorce as well, and then talk about some other things while we have time. Are there any questions you want me to answer, Melissa?
There's one question I'm going to throw out there. It's probably would be under the category of anticipated high conflict divorce.
Okay.
This person's saying that they're divorcing a business owner and concerned that they could be hiding money in the business. How can we be sure that they're not hiding money in the business?
How can we be sure that they're not hiding money in the business? Well, you probably are going to need someone, you're going to need an expert to go through the financials. You're going to need an expert to value the business. You're going to need an expert to go through the financials to do basically an analysis, somewhat of a forensic analysis to determine what's happening. I deal with cases with a lot of business owners, and it depends on the structure of the business. It depends on the quality of the books of the business. It depends on the type, if it's a cash business, if there's receipts, if it's a high credit card volume business, checks, like what's the flow? Is it set up as an S corporation, a regular corporation, a PLLC, a sole proprietorship, a PS? Like there's all kinds of questions I got when you talking like that. But how do you know that they're not hiding? Well, if you think they're not hiding and you don't trust them, and you're going to need evaluation done to know what's that business worth. You're also going to get into what's the cash flow look like? Hey, where's that money going? What does it look like? So you're going to need an expert to get involved most of the time. And that is in everybody's best interest, especially if you're looking to be bought out of a business. You want to make absolutely sure what that business is worth. And you also want to know, what's happened during the life cycle of the business during the marriage, because you have an interest in that. And if some of the money, I had a case recently where some of the money in a business was, basically being embezzled by one of the spouses, and they were trying to hide it. Well, that's a problem. And then the other spouse didn't know or didn't see it and was wondering, why don't we have any money when we looks like we do? That was why. So, it involves an expert to get involved and do what I would call a forensic tracing or accounting of the business books. So I hope that helps.
Yeah, thank you.
Okay. All right. So let's talk about the DIY divorce. I think the DIY divorce is what a lot of people want to do, but like I said at the top, don't do it. Or if you're gonna do it, get some advice to draft the paperwork and get some advice on what you're entitled to. What is a DIY? It's a do-it-yourself divorce. Can you get a divorce yourself in Washington? Absolutely. Is the paperwork difficult? Absolutely. Do I have other attorney friends who are not family law attorneys that are kind of like, I don't know what I'm doing with this? Absolutely. It would be like me trying to go and litigate an employment law claim. I'm not an employment law attorney. I know a little bit, but I don't know their language. I don't speak it. right? Or I used to do criminal work, and sometimes a family law attorney would like wade into criminal work, and it was so obvious. It was like being the new kid at school. The person shows up, they don't speak the language, they know enough, but they don't really know. They're missing critical things. Or here's another example. I I do a lot of prenuptial agreements, postnuptial agreements, and cohabitation agreements. And sometimes I'll get a draft from another attorney and I'll look at it. It takes me 2 minutes to look at it, and I know that a family law attorney didn't draft this. Somebody didn't draft this who's litigated these disputes and understands family law issues. Maybe a business attorney drafted it, or a real estate attorney, but still an attorney. They still know what they're doing, or maybe the parties downloaded it from LegalZoom. Even worse, right? And it's so obvious that it might sort of sound like a lawyer wrote it, but it lacks any kind of real important things that need to be enforced or considered, or it's missing things. And that's what happens in a DIY divorce, or when you have somebody will be like, oh, my brother's an attorney, totally different type of attorney in another state. They'll draft everything for you. I'll look at it and I'll be like, well, where's this, and this? This is totally wrong. And then they come back later and they agreed to something. Oh, I didn't know I was entitled to that. I thought we were supposed to split everything equally because it's community property state. Doesn't that mean we each get half? And I'm like, no, it does not mean that. And you just gave up a couple $100,000. Can you do anything about it? No, it's done. Poof, gone. So if you don't want to be that person that comes to me later and says that, get some freaking advice. Do not DIY. But if you have almost nothing, or you totally have already talked to people and you know what your division of debts and assets should look like, great. When is a DIY divorce okay? There's no complicated legal issues. No contested assets, no question about what things are valued. There are no DV issues. There's no significant disagreements. You totally agree on the parenting time. If you have kids, you know what appropriate child support is and you agree on that. You know if the other party is going to get spousal support and you agree on that. You know everything and agree on everything. If you know that, cool, fill out the paperwork and get some help with it and get it done. But most people don't have a clue, including me. I didn't DIY my own divorce when I got divorced, and I was already practicing family law. So, but I couldn't be objective about it. I couldn't think clearly about it. It would have been so irresponsible for me to do that. So, anyway, and that's coming from somebody that actually knows what they're doing. So it's really difficult. But if you agree on all those things and you know all those things, then by all means, go ahead. There are other approaches to a DIY divorce, which we can talk about in a minute as an uncontested divorce. But here, there are going to be four main issues that you're going to have to agree on in a DIY divorce. One, you're going to have to agree on the division of debts and assets. Two, you're going to have to agree on whether one party gets spousal support and what that looks like. Three, you're going to have to agree on a parenting plan, which is going to include a regular residential schedule for your kids, a summer break schedule, all the holiday schedules, all decision making, transportation, and extra provisions. And four, you're going to have to agree on child support, what it should be. You'll have to have worksheets. You're going to have to do those, what they look like, and what the pro rata share is for things that aren't covered by child support, like extracurricular activities, out-of-pocket medical copays, things like that, things that aren't covered by deductible, and work-related childcare, things like that. So if you know all of that, you can get advice on all of that. You can DIY your divorce. Or you can do kind of a hybrid where you might get some advice in the beginning. And then once you kind of get that advice, you might do the paperwork on your own, have somebody look at it, everybody signs off. Great. That's perfectly fine. And you do that. It's really rare though that people do it right. And so then they get frustrated. It's really rare that people know what's fair because fair doesn't exist. So it's even more rare that people know what's equitable and what would happen and what they're really entitled to. It's very common in a DIY setting where one person who makes more money will be like, oh, let's just agree on everything. Let's just split everything. I'm being really generous. I'm splitting everything with you. And I'm going to give you X amount of money for child support. And the person's like, wow, I'm so used to being controlled and they're giving me half. That's great. Well, you're probably entitled to way more than half. So that's a home run for them. But you don't know that if you don't talk to somebody. So anyway, be careful if you DIY it. The common DIY process is I downloaded some forms offline. Maybe if you're at least going to do that, at least get the Washington State Court forms. Don't do something that's not Washington form based. Go to washingtonlawhelp.org. There you go. I'll give you even a DIY resource that I like. I give a lot of people in the legal clinics I volunteer, I tell them to go look at washingtonlawhelp.org. It has a ton of resources. It's great. It's Washington specific. It has forms. It's really helpful, but it also will tell you when you're going through the process, talk to an attorney if this is your situation. So anyway, it's really, really, really important though that you look at Washington specific information. So Anyway, you can DIY. Another aspect of DIY could be um, we're going to use this is I'll say this, and I'm going to try to be neutral about it. We're going to use a mediator that's going to work with both of us. That mediator is not going to give you legal advice. They're not going to tell you what is fair. They're not even going to tell you what is equitable because they can't. A lot of the time, there will be an attorney who has great intentions and can help people come to a resolution working together. But that's a different type of mediation than what settles most cases. And then when you're done with that mediation, you're going to have what's called a memorandum of understanding of what you guys understand that you agreed to. Nobody's bound to it. And then you're going to bring it to an attorney to draft. And then that attorney is going to look at it and probably tell you it's not fair. So anyway, you might be able to come to a resolution with the help of a mediator who is what I would call a facilitative mediator. They're going to facilitate that discussion as you DIY your divorce, and you're going to kind of come to an agreement on it. They cannot give you advice because they cannot represent either one of you. So that's a very specific type of situation in mediation. So I'm going to talk about uncontested. Is there any questions before I do?
Yeah, we have a couple questions. Okay, one participant's asking, she's describing that she's in a high conflict divorce situation with emotional DV issues. A lot of hard time getting her husband to do anything or move anything forward. Luckily now working with a Dellino Law Group attorney. Um, the question is around how to get through the division of assets without getting into more heated conflicts with him, how to kind of minimize conflict with the opposing party when you're going through a tough situation like division of assets with a potentially narcissistic person.
You shouldn't be talking to them about anything.
Yeah, it sounds like they try to use the child and put the
You
child in
should
the head.
get, yeah,
Yeah.
you really, really, really probably need a guardian ad litem to help shield your child and talk to your child about what's going on because that guardian ad litem can tell the court. And if they're using your child as a pawn and they're sending messages to your child and they're in your child's ear, your child's never going to get to say that to anyone aside from someone who's going to put it in a report, which is generally a guardian ad litem or a parenting evaluator. In a high conflict case, also too, you want that person to know because perhaps your soon to be former spouse could have restriction in their parenting plan for abusive use of conflict, for abusing conflict, also for putting your child in the middle of things. So the what you can do is you can get somebody to negotiate for you, and that is what I would do, especially if you have an attorney. They're gonna negotiate for you, and it's okay to be like, "Hey, I thought I could negotiate some of this. I can't. You do it." A lot of the times, attorneys will tell you, "Hey, we should just handle this for you." But a lot of the time, they will also be like, "Oh, you want to try to work this out? Okay, sure." Because we don't want to tell you not to work things out. But if it's too much and it's a situation where your child's being weaponized and you're being, poked by this person, just say, "I don't want to deal with it." And then all communication about that should go through your attorney. That's what I would recommend. This is also a good time to talk about, like, for parenting. Oftentimes, if you're going to temporary orders or even through negotiation, our Family Wizard is an online program where all communication is kept online and tracked, and the court will sometimes order that, or you can agree to it. That's a really good way to go because then you're not going to be blown up by text message or email by this person that's used to being able to reach out and control you. So I highly, highly, highly recommend that you not engage with them. Just don't engage with them. Tell them to talk to my attorney. And then when they realize it's costing them money to do that, they might become more amicable. That's what I would hope. It's really difficult. And I'm worried for your child because you probably want to shield your child from this. And the narcissistic tendencied parent they aren't thinking about the child, they're thinking about themselves, and they know that using the child is getting to you. So you probably need a custody evaluator to get involved, and you probably need to limit contact with this person about finances. Melissa, do you have anything to add?
Yeah, yeah, under that same umbrella, I mean, for your own legal protection and for your own emotional protection, the big word here is boundaries. So you have to, this is the best time to really practice boundary setting with your communication with this person. Definitely our Family Wizard and those, communication portals are a great way to do that. Utilizing the support of your legal counsel to, advocate for you and have those difficult conversations for you is the way to do that. And really just, working with the therapist or somebody, who can help you understand how to set those boundaries. It's really hard because you're trying to hold a lot of different things here. You're trying to balance being a strong parent, not trying to create conflict, but also advocating for your own best interest and for your child's best interest. So there's a lot going on here. Get support. Make sure you have adequate support on an emotional side and obviously through your legal counsel.
Yeah. I mean, that's really the best thing. I'm really sorry you're going through it too, because
Yeah.
it's not uncommon what you're talking about, where maybe you're like trying to get information, you're trying to like just deal with things, but then you end up having somebody on the other side who's making everything a problem, and it's really stressful. So, I wish you the best of luck, and hopefully this is the good news of in a high conflict situation is sometimes the other party, they might never get it and they might be like this till the end. Sometimes they might rein it in a little bit, especially if they know people are watching, which is why I like to get a custody evaluator on board in a case like that. If you know somebody's watching, you know that, oh, this person is going to do a report. They're talking to collateral contacts, they're talking to people at the school, they're talking to your child. Like sometimes that's necessary.
Yeah.
Not in every case, but definitely in some cases. So that's something to think about.
We have another question. All of our liquid assets are in joint accounts. How quickly should we attempt to separate personal expenses prior to settlement?
Oh, well, I mean, it depends on your situation. If you're super cooperative and you want to keep both spending out of the joint account, great. That's not usually the case because um, once you have filed and you are in the next stage and you have a data separation, post-separation earnings and debts are separate. They're not joint. So you should go set up your own bank account. So if you're making a paycheck after you file for divorce or you separate, your check should be going into your account and then putting in money into a joint account if you have joint expenses. But very often in temporary orders, that's what happens. And you can do that through negotiation or court, determining who's going to pay what bills. But your money is no longer community money because the community's ended once you have a data separation. So basically setting a new normal for who's going to pay what expenses is a really good idea. That's very often a first step. And then you realize sometimes, oh, I don't have enough and this person pays more than me. Well, they probably should be paying you spousal support in that instance on a temporary basis. So dividing expenses should happen. You do have a situation where post separation, expenses and debts are separate. So it's in your best interest a lot of the time to put your check in your own account. Or if you don't have any money and they do, then you have to deal with that. So I hope that helps.
Good.
Um, okay. Let me talk a little bit about like the uncontested process, because the uncontested process is another way to look at things. So what I think about is I think about it like this. Okay, we talked about DIY. And first you have to determine how do I qualify? Are we both able to file divorce in Washington? Do we agree on absolutely everything? If yes, okay, great. If no, then we talked about maybe like a DIY mediation. Uncontested means you absolutely don't have anything else to work out. You might want somebody to help you through the process with the paperwork. So maybe you get an attorney to represent you in an uncontested case, and they're not going to go to court and they're really just giving you some advice and they're memorializing what you did. It's similar to a DIY, but you're not really doing it yourself. I would say you have somebody actually doing everything for you. Sometimes they represent you, sometimes they're just giving you advice behind the scenes and drafting everything. But for the most part, you agree on everything and there's nothing left to work out. There's nothing left to negotiate, and you're getting some help with it. We do those kinds of cases a lot where somebody might work with an attorney and everybody agrees on everything. They just really need help kind of walking through the steps and doing it. So they have representation as like kind of a guide through it and to tell you if you're getting off track or off the rails and that your settlement is not helpful for you. We also have uncontested options where people agree on everything. There's no question. They don't need that much help. We just draft the paperwork for you. You have no representation. We just draft the paperwork, memorialize your agreement, and file it. So it's kind of two different ways, depending on how much handholding and how much guidance you need. Or do you just need somebody to draft all of your documents and get you filed? We can do that too. It's different than a DIY where you may or may not agree on things. You're totally trying to do it yourself. You're downloading forms. You're doing this or that. Maybe you're trying to use a mediator. You don't really know. You're throwing. I think of DIY as like, I'm going to throw pasta at the wall and see if it sticks or not, right? And if it sticks, oh, maybe we'll go with that. If you're doing an uncontested process, maybe you're getting more assistance, but you're still not nothing is in dispute. However, if you have representation in an uncontested process, then if things go sideways, it can kind of vamp more into what I would call the cooperative process we talked about earlier. That's actually pretty common. Someone thinks it's totally uncontested, and then they realize they don't agree on how much the house is worth, or they don't agree on the terms to buy out the house, or they don't agree on how they're going to split up Christmas break with their kids. Well, now you're not uncontested, but at least you have an attorney on board, and we can try to negotiate these things and keep it cooperative and keep you moving ahead. Whereas opposed to if you were DIY and you had those things come up, you wouldn't know what to do. And it can turn into a real mess. So I hope that helps. So we've talked about DIY, we've talked about uncontested, we've talked about collaborative, we've talked about cooperative, which I think is kind of your sweet spot. And we've talked about high conflict litigation. So that is a number of things for you to think about. What is best for you? I don't know. I don't know you, but I do know that it's not going to be the same for all of you. And the best thing that you can do is really evaluate who's helping you, getting an attorney on board that can help you with the style that you want, understanding if the style that you want is realistic for your situation. You probably need to talk to somebody about that too. Like I told you earlier, someone comes and they're like, oh, I need a protection order, but after that, I want to go collaborative. Well, that's not going to happen. Or, oh, I want to be really cooperative. But instead of saying they want to be really cooperative, the other side is like, I'm not going to give you any documents. So then you're going to have to go to court. So you need to kind of figure out what's the right style for you, what's the approach you want to take, make sure you have the support to do it, make sure you have the emotional support in your corner, especially because no matter what you're doing, you're dealing with a major life event and a major life change. Anyway, but more than anything, you guys are like all way ahead of the curve because you showed up to get some information and to have an idea what these things mean. I will tell you what, it's a whole different vocabulary. We often talk about it at my office, like speaking the language, right? I had a newer attorney talk to me, and I was telling him, that it really took me when I started my family law practice, it took me a good 3 years to really felt like I spoke the language and was fluent in divorce. I knew the basics, but I didn't speak the language. In criminal law, it was the same thing. I didn't speak the language, and so I recognized the other attorneys coming in that don't speak the language because I had to learn it. So you want to make sure you have somebody that speaks the language to get you through this, because this is not a language you ever want to speak again. You don't want to know it. You don't want to do it. You want to get through it, learn a few things, and move on. So you've taken a really important first step by doing that today. I'll just leave you with telling you we've got a bunch of videos over the years on our YouTube channel, other webinars I've done, other things like that. So you'll see me if you see my early ones when I looked younger versus now. So anyway, it's a whole range. We do these every month. Melissa is a fabulous co-host. She's also a fabulous therapist. I can't tell you enough how whether it's her or someone else, having a therapist that understands relationship transitions is really key, and can help guide you through the situation. And then I'll also tell you too, you might, I don't know if we have any spots left, but you might want to check out on our website. There's a link to our meetup, meetup.com. I co-host a group called the Do's and Don'ts of Separation and Divorce. So we actually do one in-person meetup a quarter, and it's next week. It's next Thursday night in Bellevue. So if you are interested in that, we might have a few spots left. I'm not sure, but you can go to our website or go to meetup.com and look for it. We do these once a month. We do the meetup group every month as well, online, and then one in person per quarter. The in person is free, and we have food, and you can come and chat with us live, which is much more fun for me than on Zoom. So anyway, we have a lot of resources for you, no matter what stage of the process you're in. And if you're thinking about divorce, I would highly recommend that you schedule a consultation. And if you're not sure about scheduling a consultation, a good thing for you is we have a team of client liaisons where you can call in and talk with them about your situation. They are really great. Gabriella, Amber, and Ashley, if you've ever called in and talked to anyone in our office, they're going to be the first people you talk to, and they're going to talk to you about the process before you ever decide to schedule, and that is complimentary. So anyway, get your resources. Thank you for coming today. Thank you for the great questions and giving me your time. I wish you nothing but the best. Take care.
Thanks, everyone. I'm going to leave this contact slide up here for just a couple of more minutes. In case you would like to reach out to Michelle's firm, you're welcome to reach out to me as well if you're interested in counseling services. And definitely check out some of the future events. The meetup groups are great. There's also a financial advisor and a realtor and a mortgage person there. I attend those as well as Michelle, a whole bunch of different people who are really equipped to help with all the different divorce needs all in one spot. So those are really wonderful events. Okay, so we hope to see you next time. I will leave this slide up for a couple more moments in case anyone wants to copy down any more information. Thanks so much.